number 7, the people of the state of New York versus Damon Wheeler.
Morning, Your Honors. Richard Hirschfeld for appellant.
Good morning. 1 second, counsel. Mr. Hirschfeld, do you care to reserve rebuttal time, sir?
Yes, please. 3 minutes?
3?
Yes. Thank you. So the primary issue before the court is the sufficiency of the accusatory instrument, where it describes the official government function as a quote-unquote proper vehicle stop. The first thing I'd like to point out is that although the prosecution interchangeably refers to this as a traffic stop, that's not what the accusatory instrument says, and in fact, that's not what this was. The accusatory instrument simply describes it as
Counsel, let me ask you this. If we were to find, just assume for a moment, that the official action in this statute does not need, you don't have to prove, it's not an element that it be authorized, is the misdemeanor complaints facially sufficient?
I don't believe it is, but I think
But why not?
Because the law requires, the cases of this court require that you provide sufficient factual information to allow the defendant to present a defense. Where you simply say proper vehicle stop, and you can't use conclusory language to meet that burden. You have to have
there's not
actual
notice with the language that they use by saying proper vehicle stop.
Doesn't provide notice. Yes, that's our point, Your Honor.
So do we have to actually decide then whether authorized is an element? I know that's how it's written in the CJI, and I know that there are many appellate division cases that say that. But have we actually ever said that?
I believe Alejandro addresses that. Judge Garcia disagrees with me.
I think that's an unlawful arrest case.
I'm sorry? Yes,
That's
it's
a
a resisting arrest, but
case.
it's still required that the arrest be authorized.
Resisting
That's in the
arrest,
statute.
the word authorized appears in the statute, right?
Yes.
It doesn't appear in this statute.
Well, but, I mean, you can infer it from the fact that it's an official government function, and it's not an official government function unless the act is authorized. If it's an unauthorized act, then you lose the statute isn't complied with. So I think that you have to read authorized into that.
Isn't that official? I mean, if that's really an official act. So what you're saying is official is the same as authorized?
No, I'm saying that to be official, it has to be authorized. If it's unauthorized, then it's beyond the scope of the individual's authority, and therefore it's not an official act.
So if someone is serving like a bench ticket or a bench warrant or whatever, and they believe that that is a duly authorized warrant, and it turns out for legal reasons it isn't, you can interfere with that function because it's not official.
No, not at all, and this court's already addressed that, I think, in Kafara.
So why, what's the difference?
The difference is if you have a facially, and I think that's the language in Kafara, a facially sufficient warrant, so you have an objective standard for the officer, then you're acting in your official capacity because...
So it's an objective standard for the officer believing it's authorized?
No, I mean, if it's
Because you can see why the legislature might make this distinction, right? In an arrest confrontational situation, they've required that to be authorized. But in a vehicle stop, let's say, traffic stop, which I know your point on that, but a traffic stop, they don't want the driver saying, you know, my taillight really isn't out. I can back half a mile up the road because I wouldn't be obstructing you.
No, but if the officer said, I stopped that vehicle because I didn't like the color of the shirt he was wearing.
No, but let's say I believe the taillight was out, and then ultimately they find, or one of these cases where there's an obstruction, a mirror or whatever, and ultimately it turns out it isn't. It wasn't a reason to stop it. Can the driver then say, you know, I don't think my taillight is out, I'm going to back up?
No.
Because I'm not going to be guilty of obstruction, you know, in a government function. It's not official.
I think we're taking this a step beyond into trial proof at that point.
But I thought your point was that the instrument didn't say.
Exactly. It's a notice
Your
issue.
the light is out.
Right, exactly. It's a notice issue, as Judge Feinman suggested.
It would be a different case if they had explained why they
But I don't
stopped.
understand that, because isn't the rule that you have to make non-hearsay allegations in the complaint of all the elements of the crime? So it matters to the complaint that you've alleged that or not, right? Isn't that Dryden in the other cases?
Right.
So, yes, it's a trial-proof issue, but aren't you saying then it isn't a trial-proof issue? You need to prove authorized. If we say it's required in the misdemeanor complaint, we're saying it's required to be proved at trial under an element theory, which I think is your main theory. Right? It's an element and it wasn't alleged
Well, my
in
main
non-hearsay
theory,
form.
as Judge Feinman noted, is a notice issue. And empirically, if you look at what happened here, nobody knew what was going on. The warrant was sprung on the defense at the last minute. Nobody knew which warrant was executed. And if you look at the requirement that you have sufficient facts to allow a defendant to defend, I think empirically you can see that standard.
So
was-
would it be, under your analysis, would it be sufficient if it said affecting a proper vehicle's stop pursuant to a warrant? Is that enough?
I believe that would be enough, Your Honor, and then it's up to the defense to take a look at the warrant and decide whether or not the warrant was facially valid.
What if it was a vehicle, a traffic stop? How much detail would you have to give for that?
Just the basic of the reason for the stop. I mean, if
You have to say what VTL provision was violated, or just, can
No,
you
I don't
just say for a violation of the VTL? Is that enough?
I think you need to provide the specifics of why the vehicle was stopped. If you look at any of the cases that the prosecution cites about, hyper-technical pleading, they talk only about not being required to use the word authorized or legal, but they provide a factual basis for the underlying action. The Myers case, relied on by the appellate term, talks about an assault by the defendant on the officer with a pipe. So if it's a vehicle stop, I stopped the vehicle because of X, Y, and Z.
But that's what I'm asking. What is X, Y, and Z? Because the taillight was out, violation of VTL section whatever, or can it just say because I observed a violation of the VTL?
No, I think you need to specify the nature of the violation. It's not so much.
So let's say he's making a left turn from the right lane, all right? Can he just say, I pulled him over after I saw him making a left turn from a right lane? Or I think what Judge Stein is getting at, do you have to identify the specific VTL section?
No, I'm saying I don't believe you have to identify the VTL section. I think it's necessary to advise the defendant of the factual basis for the underlying act that precipitated, whether it's resisting arrest or obstruction.
So
of
then
justice.
either one would be enough? You can either describe the actual conduct or the section that is violated by the conduct, because you can go look it up, of course.
I don't believe citing the statute would be sufficient at all.
Well,
because-
not just the VTL, if you actually gave the section,
No,
which
I-
allows someone to go look at the section and know what the conduct is.
I guess it depends on the nature of I mean, if the section is specific enough so that the defendant is going to know he was pulled over for making a left-hand turn from the right-hand lane, but if it's simply incautious driving, then you don't know what you did.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, I'm Andrew Cass. I represent the people in this matter.
So can I start with whether you're conceding that it's an element of 195.05 that the underlying government function has to be authorized?
We're not conceding that for pleading purposes, because that becomes an aspect of a defense, a potential defense at trial.
But if it's the people's burden to prove, which I understood you were saying, that you agreed that it was the people's burden to prove that it was authorized at trial, right? So how can it be an element for the crime at trial and not be an element for pleading? I don't understand that.
Let me give an example here, and I think, first of all, defendant's case illustrates that, because at trial itself, then there was the factual issue regarding the date of the search warrant. So that was presented as a question of fact for the trier of fact at trial. Now, getting back to your...
But that doesn't change whether it's an element of the crime or
Well,
not.
but it becomes almost like a defense, where then the people had the burden then to show at that point that, in fact, in this case...
But the defense is that an element of the crime has not been met.
Unless it's a nullification defense,
Well,
right?
if I may, for example, as the court has suggested, that you don't have a legal right as a defendant to interfere with the execution, to physically interfere with the execution of a search warrant.
Right, but you
However,
have the
this
right
search-
to notice that that's the reason why you were stopped, don't you?
Well, but in this case, but if I can just finish my explanation there, right? A defendant who may later contest the facial validity of that search warrant, and it's possible that the search warrant itself could be found to be defective. But it's the same way with resisting arrest, where a defendant could be acquitted, right, of the underlying allegation, but yet convicted of resisting arrest, because you're dealing with a different standard, right? A proof, a probable cause versus proof beyond a reasonable doubt.
I understand that, but there's elements to the crime of resisting arrest,
Sure.
right? And you agree that I think, maybe you don't, that the accusatory instrument that an information has to establish those elements to be valid.
Yes,
right?
but
Okay, so why is that not the same principle for obstructing governmental administration or any other crime?
Well, because the legislature did not specifically include the term authorized official function, in contrast to the specific inclusion of authorized arrest. But it's also, in this type of case, you could reasonably infer, because not only were they alleging that they were making a proper vehicle stop, but the...
Well, what does that mean, a proper vehicle stop?
Well,
How does that tell you anything?
Well, because we're not limiting ourselves to just those specific terms, but it was in the context where the...
Well, but that's the
accusatory-
official function, right? That you're saying was obstructed here, right?
Yes, but
the
it was-
proper vehicle stop.
But the officers also had alleged that it was also under circumstances where they also had their lights and sirens, so that it activated, so that it's more than just saying I was making a traffic stop or a vehicle stop. But it was under...
That explains how they facilitated the stop. I mean, I think his point is, you can put on your sirens and all of that, but that's not explaining what's the lawful basis for doing any of that to get toward, to actually stop the individual. And they just want to know in the instrument, and that's what our law says, what's the basis for the stop? Well, that's their argument, right?
Yeah, I understand what the court is asking, but that's the distinction, what we've had,
So
because...
is your position, if it was an unmarked car, no sirens, then this would be an insufficient instrument?
If they had only alleged I was making a stop, I would concede that in that context.
Well, now you've changed it. My question was if it only said, if it didn't say anything else. Let me see, I'm trying to remember now what they're saying here. If they didn't make reference to the lights and sirens, but they still said proper vehicle stop, is it sufficient?
It might depend, and the reason why...
Well, no, on this instrument,
in
with
this
respect to
case-
this instrument.
In this case, probably not. But I just want to mention that, and I...
So emergency lights and sirens is giving notice of what?
Well,
That they're officers?
no, it's giving additional inferences from which the reviewing courts can infer that the police were engaged in an official function. in that they're affecting a vehicle stop and they have their lights and sirens on. It's in that context that you can infer that
Well,
they're...
but haven't we all heard stories about, police doing that because they see somebody, they don't like the way they look, they don't think they belong in the neighborhood, or maybe it's somebody they know. Maybe it's not proper for them to do that, but they do that. But here, I think there's a clear example of what the problem is, in that this defendant did not know whether he was being stopped for something that a violation of the vehicle and traffic law, or something else. And in this case, it was something completely else. It was a search warrant based on different transactions. So how does the proper vehicle stop in that case give him notice of the basis for the stop?
Well, the interesting aspect about this case, at least factually, from what we know from the trial evidence, is that the defendant actually put the car in reverse and took off before the police even had the opportunity to announce the search warrant. So you're saying he's entitled to notice for something which, at least on the facts of this particular case, really didn't affect...
But we don't look at the trial evidence. We're talking about the four corners of this information,
I
right?
agree with that.
So let's try to stick to that.
I agree, but it's an interesting aspect about this case.
Counsel, it seems to me, and putting aside, I think, what's been asked about recently about notice, and it's kind of another area to examine the sufficiency, and your adversary makes that point. I think you're in a difficult position because in the appellate division seem to have been imposing this authorized element into this crime, which we have never said. So I think concede or not concede is a tough position for you to be in, because I think that may be the law where you in your department. But it comes down to, it seems to me, on that point, not the notice point, what are we going to say official means if we get to that issue? And is official the same as authorized? Because there's no defense unless it's an element. So what would you say official means in this statute?
Well, I think by analogy, we might agree that, for example, even if a police officer makes an unlawful stop, and there was a question earlier regarding a potential discriminatory stop or something, right? When we look in the civil realm, we do look at 1983 actions, whether somebody's acting under the color of law, whether the action is lawful or not. And I think that's what we're kind of...
So in the course of their authorized duties, perhaps authorized, poor choice of words maybe there, but in the course of their duties as a government official.
I think that's what we're looking at. And just by...
Are you familiar with the 1931 case from this court, O'Connor, which was a per curiam decision where they basically glossed on authorized, and if that case is still valid, because obviously it deals with the penal law from the late 1800s or early 1900s. But assuming that that's still valid, why can't we gloss on authorized as an element into this definition of official?
I see that my time is up. May I
Yes,
briefly
please.
answer Mr. Feynman's question? Thank you. If I may, I think what I would ask the court to look at, and I admit that I don't believe I include the site in my brief. There's a decision by this court in 2014, People versus Dumay, D-U-M-A-Y. It's 23 New York 3rd, 518. And in that case, the court said that it was a obstructing governmental administration case. And the court said that the official function in that case, or the official function that was identified was a neighborhood patrol, that the allegations were, it dealt with physical interference, but somebody banged on the hood of a patrol car and prevented the patrol car then from entering the street and the officer continuing with his duties, but it made only reference to neighborhood patrol. And in that context, a neighborhood patrol, a proper vehicle stop, right? The court had, nowhere in that case did they say that there was an issue when it came to defining the official function. We understood neighborhood patrol is something a police officer would do. And I think in this case, a vehicle stop, when you have your lights and sirens activated, we understand that to mean an official function.
Thank you, counsel.
Thank you, Your Honors.
Counsel?
Thank you. Very briefly, I just would like to address lights and sirens. Lights and sirens tell you how the stop may have come about. It doesn't tell you why the stop was made, so it really adds nothing to the notice provisions. If the court has no other questions,
Thank you,
I'll rest on my
counsel.
brief.